Hello and welcome. Thank you for joining our webinar on a practical guide to pensions litigation. This webinar forms part of Mayor Brown's annual pensions conference, which is a series of webinars covering current and upcoming topical matters relevant to the pensions industry. I'm Stuart Pickford, and I'm joint head of our pensions litigation team. I'm joined by my colleague Tom Wild, who is a senior associate in the team. During this webinar series, we will address topics including investment structures and related tax considerations, changes in pension scheme investment compliance and disclosure requirements, GMP equalisation, covenants and funding, effectiveness of trustee boards, and the Pension Schemes Act 2020. What we thought we'd do today is run through three aspects of pensions litigation. Tom is going to look first at complaints by members. What we're trying to do here is share some practical thoughts on the effective handling of these complaints through the IDRP process and then potentially through to the Ombudsman. Tom will then look in a bit more detail at overpayment cases. I'm then going to look at how going to court can help trustees to navigate through and resolve difficult problems. With that, I'll hand over to Tom to deal with member complaints.
Yes, thanks, Stuart. So I'm going to start by considering complaints by members. Member complaints are not uncommon, and many listeners will have personal experience of dealing with them. Some of the common sources of member complaints are listed on slide 2. They include things like contentious decisions by the trustee, so exercises of discretion, or sometimes assessments of evidence, like medical evidence in serious ill health cases. Disputed benefits, like pension payments made at the wrong time or in the wrong amount, or disputes as to the member's entitlement under the rules of the scheme. Delays can often give rise to complaints. And a common example of that is where there's a delay in transferring benefits to another scheme. Sometimes information that's provided or not provided by the trustee, such as information about the scheme's investments or benefit quotations, can give rise to complaints, as can failures to protect the member, which is commonly in the case of pension liberation scams or similar issues. And finally, actions taken by the trustee, such as actions to recover overpayments, which I'm going to come on to later, can also give rise to complaints, although that's obviously not an exhaustive list. Sometimes the complaint will also be by a non-member, such as a dependent or a former member. That sort of complaint might include issues around death benefits, disputes as to membership status, or disputes following a transfer out. Now, with all of these, in our experience, members may not always be entirely clear as to what exactly their complaint is about. Even members with a good general understanding of their benefits are unlikely to fit a complaint neatly into a legal framework. Where the real nub of the complaint isn't clear is for the trustee to take a step back from what the member has said and try to work out what the complaint is really about and whether something has gone wrong. Depending on the complaint, one approach might be to think about what steps should have been taken in the circumstances and whether those steps were in fact taken properly. It's important to bear in mind that if the member has raised a valid issue, the trustees will need to remedy the position, even if the member hasn't articulated their arguments very well. All occupational schemes are required to have in place a standard procedure to follow when addressing a member complaint, which is the scheme's Internal Dispute Resolution Procedure, or IDRP. These are scheme-specific, so you'll need to familiarise yourself with the IDRP for your scheme, although most are fairly similar. Most schemes will have a two-stage IDRP, which means that a member will have 2 goes at bringing their complaint. The first stage is usually for the pensions manager to consider the complaint. The pensions manager will need to consider the member's representations and any evidence submitted in support of their position. If the member isn't happy with the response at stage 1, they'll then have the option to escalate the complaint to stage 2, where it will need to be considered by the trustee board. If a complaint does get to stage 2, it's important for the trustees to take all relevant considerations and evidence into account, and to disregard all irrelevant considerations. It should be a full reconsideration of the complaint, rather than just an appeal from stage 1. At both stages, TPR will expect the scheme to reach a decision within 4 months and to communicate it to the member within another 15 days. It's usually good practice to give reasons for the decision, and the Ombudsman in particular is likely to be critical of trustees who don't give reasons. Obviously, pensions law can be difficult to navigate, and help is available for members in the form of the Money and Pension Service, or MAPS, who can advise the member as to the strength of their position and review and explain scheme documents. Members must be told about their ability to seek free advice from MAPS, and they can do this at any time. Their involvement is not limited to disputes. Separately from MAPS, members who are involved in a dispute can approach the Early Resolution Service at the Pensions Ombudsman. Like MAPS, the ERS can give the member free advice, but they can also negotiate with the trustee on behalf of the member. The ERS's objective is to settle the complaint early, so the parties don't need to go through further lengthy processes. The ERS can become involved at any stage in an IDRP, or even before an IDRP has been commenced. Having the Early Resolution Service on board can often be helpful for the trustee as well as the member, as they can help the member to focus in on the real issue in the complaint. And if the member is in a weak position, they should explain that to them. Whenever you're dealing with an individual complainant, there is always the possibility of them taking steps outside the IDRP process. We've seen members bring claims against a trustee in the county courts, although that isn't common. What is increasingly common is for members to exercise rights under data protection law, particularly by making subject access requests. These will need to be dealt with on their own time frame, alongside the IDRP. We've discussed that the IDRP will usually give members 2 bites of the cherry. If they're happy with the trustee's decision at stage 2, things will continue in accordance with that decision. The IDRP isn't legally binding, but it can produce a result that the member is happy to live with. However, if the member isn't happy, he or she can take their complaint to the Pensions Ombudsman. You should bear in mind that trustees are required to tell members about their right to escalate a complaint to stage 2 of the IDRP and subsequently to the Pensions Ombudsman. It's worth having template letters available in advance to make sure that this isn't missed. The Pensions Ombudsman provides the member with an independent forum where they can argue their position without having to deal with the formality and costs risk that would come with bringing a claim in court. The current Ombudsman is Anthony Arter, and until recently there was also a Deputy Ombudsman, although that position is currently vacant due to a drop in TPO's workload over the last year. It's worth mentioning that the Pensions Ombudsman Adjudication Service, which can consider complaints by members and produce a decision, is an entirely separate function from the Early Resolution Service referred to a couple of slides ago. There was probably a time when the Ombudsman was regarded, rightly or wrongly, as delivering rough justice and generally coming down on the side of the member. If that view was ever right, it doesn't reflect our recent experience. And in fact, looking at the Ombudsman's most recent annual report, less than 1 in 5 complaints are currently upheld. The Ombudsman can determine disputes of fact or law, so, for example, disputes about the proper construction of scheme rules or about an individual's entitlement to benefits. The Ombudsman can also consider complaints of maladministration, which includes failing to apply the rules correctly, but also includes things like excessive delay or general incompetence which falls short of a breach of trust. Slide 7 sets out the procedure that the Pensions Ombudsman will follow. The first step will be for the adjudication team to consider whether they have jurisdiction over the complaint. Here, they'll consider whether the complaint is about an occupational pension scheme, whether the IDRP process has been completed, and how long ago the events in question took place. Generally, the Ombudsman will expect a referral to be made within 3 years of the act or omission which gives rise to the complaint, unless there's a good reason to bring it later. The complaint will then be allocated to an adjudicator, who will consider the arguments and evidence before producing an opinion. The adjudicator will usually correspond with both parties during this stage of the investigation. And in our experience, it's generally worth setting out the trustee's position in detail at an early stage to reduce the need for multiple rounds of questions. The adjudicator will produce an opinion, which the parties are free to accept, but if they don't, the complaint will be referred to the Ombudsman himself. The Ombudsman will generally produce a preliminary determination and invite both parties to give comments before producing his final determination. The preliminary determination stage is probably intended to make sure that the members understand the issues which the Ombudsman is focusing on and give them a last chance to make submissions on those issues. However, the preliminary determination stage also gives the trustees a final opportunity to persuade the Ombudsman as to their position. And in our experience, it is sometimes possible to persuade the Ombudsman to change their view at the preliminary determination stage. You should bear in mind that these investigations can take some time. The Ombudsman estimates that from beginning to end, their investigations take an average of about 5 months at the moment. But in complex cases, that can be longer, and particularly where multiple rounds of correspondence are needed at the stage of consideration by the adjudicator. If you're concerned about the length of time an investigation is taking, it's worth engaging with the adjudicator, see if steps can be taken to speed things up. As well as deciding questions of fact or law, the Ombudsman has a number of powers, which are summarised at slide 8. He can direct the trustee to take or refrain from taking steps, including reconsidering a decision or reinstating a benefit. He can also require the trustee to re-exercise its discretion if a decision has not been taken properly. The Ombudsman can also make financial awards. The more common type of award is to require the trustee to pay compensation to the member for any distress and inconvenience they have suffered. These awards generally fall in a range of around £500 to £2,000, although larger awards are possible in exceptional cases. In some circumstances, the Ombudsman has ordered financial compensation or legal costs, but this is less common. A recent example was an award in respect of lost investment returns in favour of a member whose transfer out application was processed late. A decision of the Pensions Ombudsman is legally binding on all parties, like a court judgment would be. All determinations are published on the Ombudsman's website, and while the member's name will be anonymised, the name of the scheme won't be. Following a determination by the Ombudsman, either party can seek permission to appeal to the High Court. Trustees should consider the balance of the cost and benefit of an appeal. If the Ombudsman's determination has relatively minor financial consequences for the scheme, such as an award for distress and inconvenience only, the cost of appealing to the High Court might easily outweigh the downside of just accepting the determination and moving on. However, because the determination is published, trustees should be prepared for the possibility that if a member's complaint succeeds, other members are likely to see it and may bring complaints of their own. There may therefore be circumstances where it's worth appealing a decision, even if its financial impact taken on its own is likely to be outweighed by the cost of the appeal. Obviously, the other factor trustees will need to bear in mind when deciding whether to appeal is the strength of their position. Appeals are only available on points of law, so you won't generally be able to challenge a factual finding by the Ombudsman. I've just spent the last few minutes talking about member complaints. Moving on to slide 10, there is another common source of disputes with members, which is benefit overpayments. There are a number of scenarios where benefits might be overpaid by mistake. There may have been a simple calculation error on retirement or during a benefit rectification exercise. Or the trustees might discover the rules have been applied incorrectly, resulting in a number of members receiving incorrect benefits over time. A common scenario is where a pensioner member dies, but the scheme does not find out for some time and continues paying the member's pension. In each of these scenarios, the trustees will have a claim against the member to recover overpayments which were paid by mistake. That claim is an asset of the scheme, and the trustees will need to take reasonable steps to realise it. The scheme can also face a tax charge for paying unauthorised benefits, so the tax implications of any overpayments also need to be considered. In any case, the first step for the trustees to take will be to approach the member to request repayment. If external advisors or scheme administrators were involved in the mistake, it is worth contacting them at an early stage as well, and giving them an opportunity to comment on your approach. There may be circumstances in which it's impossible to recover the overpayments from the members, and involving the external advisors or administrators from an early stage may reduce the scope for them to criticise the trustee's approach if the trustees ask them to cover the shortfall later. Some members may agree simply to repay the overpaid amounts, but it's often far from intuitive for a member to understand why they should need to repay amounts to the scheme in circumstances where the error is not their fault. You may therefore need to consider what options are available to compel the member if they won't make repayment willingly. One option is recoupment, which means reducing future pension payments until the overpayment has been recovered. It's common for trustees to achieve this by abating future increases, rather than outright reducing the member's pension so that their lifestyle isn't affected too greatly. However, recoupment will only be an option where the member does not dispute the trustee's right to recover the amount. As a practical matter, it will also only be available where there is still a pension in payment, so not, for instance, in cases of overpayments after a member's death. Where recoupment isn't available, the trustees can bring a claim in court to recover the amount from the member for his or her estate. However, this step shouldn't be taken lightly. Litigation always involves a commitment of time and resources, and it's necessary to balance the cost of litigation against the potential benefit of securing a judgment. A court fee will be payable up front in order to commence proceedings, and the legal fees associated with taking this step can also be significant, as you'll need to be sure of your case before issuing a claim. Before commencing court proceedings proper, the trustees will generally be required to write formally to the member, setting out the basis of their claim and giving the member an opportunity to respond. In our experience, it's advisable to set out your position in detail when writing to the member to request repayment. If you've already satisfied the procedural requirements for explaining your case to the member, you will not need to incur further legal costs and delays by writing to the member again. However, if you want to choose this route, you should speak with a lawyer first to make sure that the formal procedural requirements have been satisfied. This can also be a good time to properly stress test the strength of your position before committing yourself to litigation. Once you commence a claim in court, you will find yourself on a relatively rigid and brisk timetable controlled by the court. This commits you to taking steps to gather evidence and exchange it with the member. You will need to engage with the court on procedural issues, and ultimately the claim may proceed all the way to trial. All of these steps can be expensive, time-consuming and stressful for both you and the member. There are also defences available to members. In particular, claims of this nature become time-barred after 6 years, so overpayments older than that will be irrecoverable. Members also have access to a defence called change of position, which applies where the member has already spent the overpaid amount in good faith, perhaps on a holiday, or given it away. Other defences are also sometimes available, although less commonly so. For all of these reasons, trustees should be exploring the possibility of reaching an agreed settlement with the member from an early stage, so as to avoid the further costs and uncertainty of litigation. This may be easier if the member is taking independent advice. One practical point which can sometimes be overlooked is whether the member has sufficient assets to make the repayment in question. In some cases, for instance where the member owns property, you may be able to be fairly comfortable that the member can satisfy any judgment. However, often it's more difficult to get a clear view of the member's assets. This is also relevant to the question of costs. The court will generally order the losing party in litigation to pay the successful party's legal costs. However, this will be of little use if the member has insufficient assets to make the payment. Conversely, the trustee will be at risk of paying the member's costs if the claim is unsuccessful, or if the trustee decides not to pursue it all the way to judgment. On top of those issues, litigation against individual members can often be drawn out and emotive and carries a real risk of reputational damage for the trustee. Taking all of this together, there will be cases where the right approach is to bring a claim. However, trustees are not required to pursue every overpayment to the stage of issuing court proceedings. You can and should carefully consider the likely costs and benefits of court proceedings before taking steps to bring a claim. Once a claim has been commenced, it's generally much less easy to back out. One final step to consider if you decide not to pursue an overpayment is whether to exercise the scheme augmentation power to increase the member's entitlement in line with the amounts actually paid. Where possible, this can cure any breach of trust associated with paying benefits at an incorrect level, and can also avoid incurring an associated tax charge.
Thanks, Tom. Turning to applications to the court, I'm going to start with an overview of some common issues regarding what might be called the internal workings of a pension scheme, rather than claims against third parties. So why might trustees want to consider seeking the court's assistance? The slide shows 5 situations where an application to the court might be one of the options to consider. First, where there is real doubt regarding what the rules mean. Trustees and their advisors have to interpret the rules all the time, but there may be cases where the question is so difficult, or the issue so contentious, or the sums involved so large, or even a combination of these factors, where going to court makes good sense. Second, claims to determine points of law. Again, trustees look to their lawyers to advise on the law, but there may be issues that are so uncertain and so important that it makes sense to go to court. Issues of this nature, on which we've obtained definitive rulings in recent years, have included whether a scheme is open or frozen, and whether or not a scheme is segregated, points that can have significant impact in the context of the employer debt regime. Third, claims to seek the court's approval when making a momentous decision in the life of the scheme, to get comfort that the trustees are acting within the scope of their powers, and that it can't be argued later that they have exercised their powers improperly, or that something has gone wrong in the decision-making process. The objective here is to enable the scheme to move forward, having protected the decision from future legal challenge. Fourth, to resolve deadlock. This tends to be seen more in the private trust world, so I'm not going to say any more about this one for the moment. Finally, where something has gone wrong with a document, so that it doesn't say or do what was intended, the court can help to put that right. So what does a pensions application look like? Well, every case is different, but I'm going to attempt an overview of a typical application. The key document is the claim form. It identifies the parties to the case and their role. In general terms, there needs to be someone arguing for and against whatever question is before the court, so that the judge can hear both sides of the argument. The claim form sets out the questions that you are asking the court to answer. Often there will be a dialogue between the parties as this is put together, to make sure that everyone agrees that the right questions are being asked and that nothing has been overlooked. The claim form normally also sets out how the costs of the application will be dealt with. I'll come back to costs in a moment. The claim form is accompanied by one or more witness statements, setting out the factual background that the judge needs to know and the key documents the judge will need to consider. The other parties can serve witness evidence in response. A good practical way to speed up the process, where there isn't really any factual dispute, is to get the other parties to review the witness statement in support of the claim before it is finalised. They might have useful ideas about what needs to be covered, but if you can get them comfortable that everything that needs to be covered has been covered, then they might not need to put in their own evidence, and the case can move forward more quickly. From this point onwards, nothing is really set in stone. The parties and the court can work out the procedure that should be adopted that best suits the particular case. For example, whether there needs to be a process for gathering documents, or whether the court needs to hear expert evidence at trial. These cases tend to involve a small number of well-known pensions barristers and solicitors who are known to each other, and the barristers are known to the judges who hear these cases. This means the judges can generally be confident that the parties can work out between themselves the procedural framework that best suits a particular case. The court will step in to decide any disagreement, but will often go along with what the parties have agreed. As the case gets close to trial, the parties will often draw up a list of issues. This is a very useful document. It's a means to set out precisely what the court needs to decide in order to answer the questions on the claim form. The trial will be in front of a single judge, and the length of trial can vary enormously. We have had pensions cases on narrow but important technical points that have been finished within a day, and at the other end of the spectrum, cases that have lasted several weeks and involved cross-examination of witnesses and experts. The general rule of thumb is that the judges are expected to give their judgment within 3 months, but it often happens much more quickly than that. It really depends on the scale and complexity of the case, the other demands on the judge's time, and whether the decision is needed with particular urgency. An important objective is to get a final answer that is binding on everyone with an interest in the scheme. But it's not going to be feasible to join every member and other beneficiary as parties to the application. The answer is to designate a representative beneficiary, or Rep-Ben, a member who is appointed to represent the interests of a larger group. This can be done on a class basis. For example, one member representing everyone who accrued benefits during a particular period. Or it can be done by reference to the issues. For example, one member representing everyone in whose interest it would be for, say, question 1 to be answered yes. If someone else is representing everyone with the opposite interest, so those in favour of the no answer, then you know that everyone is covered and no one is going to fall between the cracks. I've mentioned members acting as representative beneficiaries, but the employer or the trustee can also act in a representative capacity. In complex cases, getting the representation structure right plays a key part in managing the case, making sure that there is someone to argue for and against each point without duplicating effort or costs. The Rep-Ben generally has quite a limited role. It's often said that they are effectively lending their name to the proceedings, with a legal team appointed on their behalf. From the perspective of the trustee, it's important to ensure that this legal team has appropriate expertise. This is both from an equality of arms perspective, and also because it helps no one if the Rep-Ben's legal team waste time and costs on bad points because they don't have the experience to focus on the real issues. So now to the crucial question: who pays the costs of the application? The general rule that the loser pays the winner's costs applies to hostile litigation, so Party A suing Party B, but does not generally apply here, where the court is being asked to determine a question concerning the scheme, and is helped in doing that by hearing both sides of the argument. Starting with the trustee's costs, the rules will often have an express power to enable the trustee to recover its expenses from the scheme assets. There is also a statutory power in the Trustee Act. The trustee will want to be satisfied that incurring costs on the application is reasonable and that costs are properly incurred, so that it can be sure that the power to recover its expenses has been engaged. In practice, the answer to this is often that the trustee has been advised that it should go to court. But in cases of genuine doubt, the trustee could ask the court for express authorization to incur costs. An alternative would be for the trustee to persuade the employer to underwrite the costs directly. This might be particularly appropriate in a multi-employer scheme. If the question is really of interest to one employer, then it might seem fair for that employer to pay rather than have the trustee's costs met from scheme assets and therefore indirectly spread between all employers. What about the employer's costs? The employer will often bear its own costs. But there may be cases where there is one employer appointed as a representative party, for example, to represent the interests of some or all employers in an industry-wide scheme. It might be appropriate here for the cost to be payable from the scheme assets, and therefore indirectly by all employers. Finally, the Rep Ben. They'll want to know that their costs will be paid. In practical terms, they and their legal team simply won't be able to get involved without that comfort. Normally, it will be clear at the outset how costs should be dealt with, so the court can make what's called a prospective costs order at an early stage in the case, confirming, before the costs are incurred, that the Rep Ben's costs are to be paid from scheme assets. The costs falling within the scope of the order will depend on the intended role of the Rep Ben, so this should dovetail with the proposed representation order. Sometimes you also see costs agreements, particularly where the employer is paying the Rep Ben's costs. Another dimension to the handling of costs is that it can help to impose some discipline on the parties to make it clear early on what costs are and are not going to be covered. Where costs are being paid from the scheme assets, the trustee has an interest in ensuring that they are reasonable, and it helps to avoid problems if the trustee has oversight in real time and the opportunity to comment on matters such as the level of brief fees for counsel and so on. There is a careful balance here, though. The trustee has to avoid getting in a position where it could be said that it is inhibiting the Rep Ben from performing their role. They must be able to fight the corner they've been appointed to fight. I'm going to look now at some examples of cases where the court has given trustees helpful guidance by determining what the rules mean. A common example would be the run of cases we've seen over the last 10 years regarding switching from RPI to CPI for pension increases, etc. The central issue often raised by these cases is, when does the power to change index arise? For example, in the Bernardo's case, one of the key issues to be determined was what was meant by a replacement adopted by the trustees. The court had to decide whether this meant the trustee had the power to adopt what they considered to be a more suitable index to measure inflation, or whether the power to change index was only engaged if RPI was no longer published. Another issue that can arise is who exercises the power. This was one of the issues in the Arcadia case, where the rules were silent on whether it was a matter for the trustees, for the employer, or for them both jointly. In that case, the court inferred from the balance of powers across the rules generally that it was a joint power. Other examples where the court has ruled on what particular provisions in the trustees and rules mean are cases regarding the scope of a power of amendment, or cases where the trustees are seeking to resolve genuine uncertainty as to the benefit provisions afforded by the rules. Cases seeking a definitive answer to a question of what a particular rule means are often run as representative proceedings. But there is another way, which can be used where there is no current dispute. The Administration of Justice Act says that if a suitably senior lawyer, in practice it will be a QC, gives an opinion on how the rules should be interpreted, the court can authorize the trustee to act accordingly, which protects the trustee from exposure to a claim that they've acted wrongly. This is cheaper and quicker than full representative proceedings, but the answer does not bind the members. A member could still come along later and say that the reading that the trustee is following is wrong. But in practice, having a judgment approving that reading can be a powerful means to persuade a member that the trustee's reading is correct. Although, as I've said, the court's approval under this procedure is not binding on the members, the court may nonetheless give directions requiring its decision to be notified to scheme members. Coming back to applications concerning trustee decisions, I put on the slide the way the court has traditionally categorised these cases. The first two are really the means by which the court can assist with those two classic questions that arise. Can I do something, and should I do something? The third category is rare in the pensions context, and I think it's fair to say that judges do not relish this sort of application. Their usual role is to adjudicate on decisions taken by others, rather than to step in as decision maker. One occasionally hears the suggestion that trustees are too willing to go to court and seek the comfort of the court's blessing, where this may not be necessary. That's not our experience. The blessing application is described in the cases in terms of a momentous decision for the scheme. Going to court is inevitably a distraction from business as usual activities. It's difficult to see why trustees would want to do that unless it was genuinely a momentous decision and the benefits of having the court's blessing outweighed the costs and time involved. A blessing application is concerned with what the trustees are proposing to do, but I should just round off this section by saying that the court will also look at what the trustees have done. Now, this sort of case might arise if there is a later challenge, whether by the employer, as in the British Airways litigation, or on behalf of members. There may also be circumstances where concerns have been raised and the trustee concludes that the best way to bring closure is to grasp the nettle itself and put the issue before the court. Finally, rectification. This is a remedy that the court can grant where there is a mistake in a document and it does not say or do what was intended. This often arises where a drafting error means that if the rules were applied as they stand, members would receive windfall benefits, perhaps at the expense of the security of other members' benefits. The particular problem that arises in a pensions context is that there are often legal obstacles to putting the problem right just by making a corrective amendment to the rules. The effect of rectification is that the rules are treated as having been in their corrected state from the outset. So the normal issues that can arise with retrospective amendments do not apply. For a rectification application, you need to be able to show to the court not only that something has gone wrong with the document, but also what the document should say. One of the criticisms of rectification is that going to court may involve gathering documents going back a number of years and speaking to those involved in the scheme when the error first arose, and possibly also those involved when the incorrect wording was readopted at subsequent points in the life of the scheme, all of which takes time and costs money. There are often calls for an easier way to sort out this problem. The counter-argument is that it is important that we can all look at a document and rely on what it says on the page, which is why the court needs convincing proof before intervening and changing it. The way the law approaches this is to say that it should not be easy to get a document rectified, particularly where the change will operate with retrospective effect. However, where the court has been more favourable is in terms of procedure. To end on a positive note, there have been very helpful innovations over recent years in the procedure for rectification cases. So in straightforward cases, where it's clear what has gone wrong, the application can be dealt with quickly and without the cost of a full trial. Let's take the classic case of windfall benefits. The best outcome for the affected members will be for the rules to remain as they stand. The Rep Ben's legal team will be looking closely at whether they have proper grounds for opposing rectification. But if not, and provided the judge can see that the issues have been thoroughly examined on behalf of the members, the court can grant rectification without a full trial.
This brings us to the end of this webinar. which forms part of this year's annual Pensions Conference. Thank you for listening. We hope you found it helpful, and please do get in touch if you have any follow-up queries. If you'd like to get in touch at a later date, please use our contact details, which are currently displayed on screen. We look forward to welcoming you again soon.